everybody. I am Nicole Thornton. Lord, I done got tripped up on my words today, y'all. Y'all know that don't happen often. Sales manager for the Cole Realty Group Atlanta. Make sure you follow me on Instagram at your real estate style pro.
Hey guys, it is Naisha Clark, coach and trainer for the Cole Realty Group Orlando. Make sure if you haven't followed me that you follow me at the right realtor ATLFL. Coach, you heard me just get tripped up.
And it's me, star celebrity Deidre Carter, sales trainer and mentor and you can reach me, Deidre, the premier agent, on Instagram. Hey everybody.
Hey girl,
hey. Hey girl, hey.
Oh, how fancy.
Oh, look at that. The one and only is gracing us with her presence today, Miss Cristyl Kimbrough with Kimbrough Law. Welcome.
Yes. Thank you so much for having me. And I look forward to dropping some gems.
Yes, awesome. And guys, make sure you subscribe to our YouTube channel at TCRG Closing the Gap.
You guys, y'all know how we do it. Before we get into the juices and berries of today, we definitely got to go over our stat highlights, all of our new under contracts for April, all of our month-to-date sales, and our Zillow squad sales. And guys, if you hear anything, I'm sorry, they're outside mowing. Perfect time to mow.
All right, we've got 12 new transactions. We are under contract for a whopping $3,130,394. Woo, woo.
Yes.
Round of applause. We got Markeisha Booker with 2 under contract. We got Nikisha Hilton with 1 under contract. We got Brandy Perry, 1 under contract. Denisha Collington, 2 under contract. Bree Haygood, 1 under contract. Sean Maddox, 1 under contract. Cherise Shepherd, 2 under contract. Chanel Downey, 1 under contract. Tamia Miller, 1 under contract. And is that all we have? Nice, nice. All right, good job,
Congratulations,
guys.
everybody.
Congrats.
Congrats.
Good job. Good job.
And Markeisha just joined us less than a month ago, so congratulations.
Listen, I'm
lady.
like, wait a minute.
Yeah,
Yes,
she's new.
You're doing a good job. You're doing a good
Congratulations. Oh, is that Orlando in the
building? Orlando
2 under
has
contract.
Nice.
Nice. Congratulations, Alicia and Keisha.
Listen, and hold on, wait a minute. Listen, I am so proud of Kaisha. I am so proud of her. This is her first deal under contract with the Cole Realty Group. This girl is a rock star. I promise you. You know how you know the little engine that keep going and going and go. Oh, she don't stop until she gets you under contract. I promise you that.
That is awesome. Nice. Congratulations.
I love it. Love it.
For the month of April, we have a total of 7 transactions closed at $2,401,885. Congratulations to Bree with 2 transactions closed, $632. Our very own Naisha Clark, 1 closed at $455,985. Got me, and then you got Wanda, 1 closed at $356,900. Sharice, 1 closed at $349,000, and Sean at $211,000. Congratulations, everyone. You want to do the honors?
Yeah, I can do the honors. April month-to-date sales, we have 3 transaction closed, $972,000. This is Orlando. Oh, I'm doing Naisha's. Naisha,
that's okay.
I'm sorry.
You can keep going. You can keep going.
But these are my students, so let me have the floor.
You got it.
Latoya Donaldson with 2 closed at $573,000, and
Nice.
Sharonda Coleman 1 closed at $399,000. Show up, team.
Listen, we coming. Yes.
I see you. I see y'all.
So excited.
I love it.
Nice. Congratulations, everybody.
Zillow total closed sales. Guys, y'all already know we got the squads out there. We got Brandy squad, Nikisha squad, and Charisma squad. I'm gonna let y'all just sit back and look at them numbers real quick because I promise you they close. We got Brandy squad with 2.2 million
Wow.
We got Nikisha Scott at 2.1 million, and you got Charisma Squad at 1.5 million. And I'm not, listen, 1.5. I ain't gonna go all down the numbers. Y'all see them though. Listen, this is crazy. This is crazy. We have not even hit mid-year. We're literally coming into May. That's it. And this is only Zillow. So guys, this is amazing, amazing, amazing. Let's keep up the good work.
Congratulations, y'all.
Congrats, guys. That
going
is
to doggone.
amazing. All of us, and we have Miss Cristyl Kimbrough, who is going to drop some jewels on us and help us get these contracts in order, guys. So
Yes.
welcome to the floor, Miss Cristyl.
Thank you,
And let me
ladies.
say that is our favorite closing
An attorney.
Why
All
not
her glory.
to, get involved in favorites? Because if you're the best, you don't have to announce that you're the best.
Oh,
No, in all seriousness, I want to go first and foremost, go over the 2022 GAR contract changes. I don't know the platform for this particular session, but I personally want to encourage everyone to interrupt me, ask questions as they come up. Like, let's engage, because now is the time, and it's straight from the horse's mouth. And my hope is that we get ahead of any issues. We're still going to have issues, but the goal is to get ahead of them before they actually manifest. Can you guys see that okay?
yes.
Yes. Uh-huh.
All right, so Section A, first of all, this is a rundown of all the changes. Some of them are important, some of them are just red tape. So they did change in Section A now, where Section A5 has flip-flopped, and Section A4, the closing firm, it gives an area for the law firm's phone number, and a section for the holder of the earnest money. I don't know if you guys have noticed that small change from last year and this year. Where they have us as the law firm, if you want a mobile closing or a closing at a specific alternate address other than our principal address, I encourage you to put Kimbrough Law - mobile closing, or Kimbrough Law - the property address of wherever you want to close. And that's a firm thing. That's not a GAR contract necessity. All right, so let's move forward. Section 8A2 says, in regards to the option payment for due diligence period, the buyer shall pay directly to the seller any additional optional money to have the option to terminate the contract. Before, it did not say that the buyer had to pay directly to the seller. And it also provides that buyers can pay via ACH transfer in addition to any other form of payment. That's important, because that needs to be distinguished from how you can submit earnest money. If, for instance, you're submitting option money and you're submitting it directly to the seller, you can do an electronic transfer. But if you are submitting earnest money and you're submitting it to the closing firm, us, you cannot use the ACH transfer. You can only use a wire transfer. So I wanted to pay a special close attention to that, because what happens is, and we talked about this on our last call, if your client accidentally sends an ACH, we won't even get notice that we have an attempted payment submitted. It'll just be rejected, and it takes like 3 or 4 days to reject and make it back to your client's account. So to distinguish between the two, if it doesn't say same day wire transfer, it's an ACH. So you can pay ACH to the seller via any form of payment besides cash. And then you can pay earnest money to the closing firm via wire transfer only. Okay.
No check, right, Cristyl? It has to be, the earnest money deposit has to be in the form of a check.
Yeah, the GAR contract specifically determines that the EMD has to be via wire transfer. What happened? Oh, I thought I heard.
Everybody, make sure you mute your phones. Go ahead.
So hypothetically, what happens if your client accidentally issues us a cashier's check or money order? If it's under $5,000, our office will accept it. But I just want you to know that could be an argument on the opposite party's side. That, hey, you weren't in line, you weren't in line with the contract. So you technically didn't submit the earnest money according to the contract. Do you really have a binding agreement? It's not a
Exactly.
strong argument, but it's an argument, and you want to eliminate all possibilities.
And I think Henry has his hand raised, Crystal. Henry, did you have something?
What's up, Henry?
Yeah,
Can't hear you. Okay, we'll come back to him, Crystal. Go ahead.
Okay, come on, Henry. All right, let's move on to section C1. And this is referring to notice, and it's referring to notices in general. So let's say you need to get a termination out. And let's say it's 11:59 and you have till midnight. There is now a caveat where even if the recipient of the email doesn't open the email, it still serves as notice if you send it. So prior to, the assumption was that you provide sufficient notice if you just send it via email. But now it explicitly confirms that even if you send it, even if they didn't open it, it still serves as notice. So I think that is just like a little legal red tape that probably doesn't occur that much. But as a broker, or as well, when they refer to broker, they're also referring to affiliated licensee, which would be the realtor. And it's just, in this section, it's explicitly confirming that the broker and or licensee is authorized to receive notice on behalf of the client. Which again, that was the assumption, right? Like you don't, as the like for instance, if you're the buyer's agent and you need to terminate the contract quickly, and you forget to CC the seller, but you send it to the seller's agent, that is sufficient notice because you've sent it to the agent for the client. And according to the contract, you can serve as the recipient of receiving notice. Is that confusing?
A little.
Okay. So you can receive notice of anything regarding the property on behalf of your client.
Okay.
The 2021 version of the contract wasn't clear on that. So there was question on whether or not you had to send it to both agent and client. But now 2022 is explicitly stating just sending it to the agent is sufficient. Now, on the other hand, you as a broker and or a licensee of the broker, the real estate agent, you're not authorized to bind the agreement. So for instance, let's say your client is on vacation and they're getting terrible reception and for some reason they can't sign the offer. You can't, as the real estate agent, bind the agreement by signing on your client's behalf, or you can't, via email say, yes, my client agrees, and that technically bind the contract. It will not. You have to have the actual client's signature. So if your clients have upcoming travel planned, make sure you account for the reception and their availability, because there's, you know how real estate is. There's going to be constant back and forth of documents that need to be signed, and you as the real estate agent cannot sign that on their behalf. And as a separate note, you also should not serve as the attorney in fact on behalf of your client. That's the power of attorney. You should not serve as a power of attorney for your client. That's not a legal requirement according to the GAR contract, but it's my professional opinion because you should stay out of it. Because if something comes up down the line, guess who's going to have to undoubtedly testify? You. And guess who's not going to be paid for their time to do that? You. And you just don't want your client saying, I didn't agree to that. Why did you sign that on my behalf? I would just stay out of it. So to sum it up, you as a realtor, you have the authority to receive notice on behalf of your client, but you do not have authority to bind an agreement on behalf of your client. Only your client's signature can. I know that seems like common sense, but I've seen some crazy things. So I don't like to assume, you know, and we all kind of get forgetful sometimes.
And Crystal,
Right.
Henry put his question in the chat. He says, I have a listing where the buyer checked both check and wire for delivery of earnest money. Transaction coordinator contacted them about the error. They said they don't have to distinguish because by checking both, it means either or is correct. And he's asking, can they do that?
So no. So I don't have an example of the closing attorney acting as the holder of the earnest money. If someone can pull that real quick and share their screen, but it specifically states that if the attorney is the holder of the earnest money, it has to be a wire transfer. Now, Henry, if you're referring to someone other than the closing attorney, then you can submit earnest money in other ways. And I actually would need to pull the closing attorney acting as the holder of the earnest money. I can maybe do it from my phone real quick and read it, because every comma, every but, every if counts. So I never like to tell you what the contract says unless I read the specific term. All right. Let's see, where are we? Earnest money. Okay. So
it's in here.
the question, just to reiterate, is if you, in this section of the section 7, if you accidentally check both check and wire transfer, which one is controlling? My legal opinion is that it gives you more than one option to send or how to send the earnest money. I don't think one would trump the other. I think it would be inclusive. So let's say you check ACH, cash, or wire transfer. So the reason why I paused is because it said or wire transfer. I still would be of the legal opinion that if you check more than one option, then more than one option applies. Is that the law? No. It's not the law until something goes to court to determine what rules. And I don't know of any case law that would support an argument that it would have to be one or the other. So Henry, to answer your question, if you accidentally check both check and ACH, my opinion is that you can submit it both ways. Does anybody have any questions about that?
Next. He said, understood. Thank you.
All right, perfect. Okay. So let me go back to share my screen. Alrighty. Where was I, guys?
Authority to bind. Okay.
So we're still under section C4. And there's just a little addition. You see where this is highlighted or bolded right here. This is regarding situations that amount to litigation or pre-litigation. So it says, it shall be resolved by a court arbitrator having jurisdiction over the dispute by written agreement of the buyer and seller, or by the holder, but only in making a reasonable interpretation of the agreement and dispersing earnest money. So what that means is, let's say you got 20 grand at stake in the earnest money. This addition is basically saying that the holder of the earnest money and or a court arbitrator may make the final decision. Earnest money is probably the #1 area that we get a lot of questions on, and a lot of agents to kind of drop the ball and lose their client's earnest money. Sometimes agents lose the client's earnest money because the client didn't listen to them. And you have explicit emails that say, this is what I think you should do, and the client chooses to do something else. In those scenarios, I don't want you to be hard on yourself, because you've given your client the likely outcome and your client chose to not listen to you. However, in situations where you should have advised your client and you failed to do so, you should feel terrible, because now your client is out $1,000 or more. So for instance, in this market especially, let's say that you don't have a due diligence period, but let's say you have a right to request repairs. Everybody familiar with that?
Mhm.
Well, I've had a scenario where the agent mentally knew that, okay, this inspection report is back. The buyer sees this inspection report and all like the exceptions. So to the buyer's mind, it looks like this is unachievable to repair. And so the buyer immediately wanted to terminate, like, oh, this is too much. I don't want to move forward. And the agent mentally knew that you had to at least present what needed to be repaired to the seller and give them an opportunity to say no before you can terminate without penalty.
Right.
However, the agent didn't clearly explain that and didn't memorialize it in email. So the agent said, okay, fine, if that's what you want to do, but I don't think you should do that. The buyer moved forward with termination and the buyer lost $15,000, literally. And the agent, and it wasn't anybody from this brokerage, but the agent felt terrible because the client didn't listen to their advice, but she also felt terrible because she knew she didn't clearly explain that you need to allow the seller the opportunity to repair. Right. Okay. And let me jump to another scenario of, maybe I shouldn't. Let me keep going because I'm going to get off in a tangent and I'm telling you, it's going to go down a rabbit hole and we won't get to the next. I've seen it happen. Okay, binding agreement date. Just to reiterate, the binding agreement date is the date in which the offer or counter offer is accepted. You should absolutely include and complete the binding agreement date because the binding agreement date is what a lot of the other due dates are contingent upon. Right. So for instance, earnest money is, 2 to 5 days from the binding agreement date. The due diligence period is, 7 to 15 days from the binding agreement date. So if we don't have, or if it's unclear what the binding agreement date is, then one agent can argue that the contingency period hasn't lapsed because there's no explicit binding agreement date. And so again, remove all question, fully complete everything. And I know that seems like common sense, but we still get a lot of even seasoned agents to not complete a binding agreement date. So this section,
I'm
go
sorry.
ahead.
I just wanted to ask you a question. Do you think that on each contract you should include the verbiage that states if a contingency or an expiration date falls on a holiday or a weekend, then the next business date is the expiration date? Because I've had that happen a couple of times where I didn't do that, and of course it fell, on the weekend, and it almost cost my client their earnest money. So do you think that's something that we as agents should get in the habit of doing?
That is an excellent question. And my response would be yes, because you don't know what it is that has to take place. Like, so for instance, if you have 2 days to submit the earnest money, but 2 days is a Saturday and Sunday, because keep in mind, when you're calculating the binding agreement date, it doesn't explicitly say business days. It's
Right.
just days, period.
Right.
So if you know you're going binding on Friday and you've only negotiated 2 days to submit the earnest money, you should already be thinking ahead and say, okay, you either negotiate a longer period to submit the earnest money, or you need to do what Nicole says and say, I don't know if you guys can write your own special steps, but you can say something to the effect of, in calculating due diligence period and or binding agreement date, all parties agree that weekends and holidays shall not constitute or be counted towards the binding agreement date and or due diligence period. And that's just something off the top of my head, but you're basically saying weekends and holidays don't count.
Exactly.
But you want to say that explicitly, just to make it clear, because you cannot submit a wire on a Saturday and Sunday. And if the contract says you can only submit a wire, well, now you're out. Now you're in breach of the contract. And now the other party has an out if they wanted to have an out.
Exactly. And in this environment, they've got multiple offers. They've got backups. They might have gotten an offer that's higher than the one that you submitted. So in order to make sure that your client is protected and that contract is valid.
Exactly.
That verbiage in there. Yeah. Okay.
Yep, exactly. No, that's an excellent question. Let's see. Objection to a binding agreement date. If the buyer or seller objects to the date entering the binding agreement date, then basically it's saying within 1 day from receiving notice of the binding agreement date, you have to object to it and send an official notice. So let's say, and I've actually had this happen, where the agent incorrectly completed the binding agreement date. Well, if the agent did not complete it correctly, you have to review it as soon as you receive it and submit notice of the objection within 1 day of notice. So you can't rest. Let's say 14 days later, you realize that the binding agreement date wasn't accurate. You can't rest on the fact that the agent didn't complete it correctly. You have to notice it as soon as it's done and request them to fix it. Because again, whatever's on the contract rules. So that all that's really saying is y'all review the contract when you get it. Don't wait. Because everything is time sensitive in real estate.
Exactly.
And you can't rest on a mistake, because a mistake is controlling. I've had agents mistakenly include additional property that the seller owned within the legal description that they attached. And so one agent was arguing that the intent was to sell the whole block, which was what was included in the legal description.
Oh.
So those little minor mistakes, like, oh, we didn't intend, how do we know? That's not what the contract says. So it seems small, but it could be potentially a huge issue.
Crystal, I think Bree had a question. I saw her hand. Go ahead, Bree.
Yes, I just wanted to backtrack just quickly. So speaking on the earnest money and the right to repair or the right to inspect, if we are still within due diligence, do we still have to give the seller an opportunity to address issues with the property?
So is the scenario, in your scenario, is there a due diligence period, or is there only a right to request repairs?
There is a due diligence period.
Oh, okay. If you're in the due diligence period, you're safe.
Okay.
That is a safe space. You can terminate because he woke up and the sky was gray.
Okay.
So,
just confirming. Thank you.
Yeah. So if you're within the due diligence period, that's a safe space. If you do not have a due diligence period and you only have a right to request repairs, then you have to go through with the inspection, present the exceptions to the seller, and let them confirm or deny. All right, so this section is a section C41. It's a really simple section, but it's a section that I really like because it's something that a lot of agents don't realize. And this is confirming that if you have a term in your special steps, or if you have a term in the exhibit, that special steps and that exhibit controls. So basically, if there's a term in the purchase and sell agreement that conflicts with whatever you freehanded in the special steps controls. That's the same with exhibits. And that's the same with any amendatory clause in the FHA or the VA exhibit. It specifically says that it trumps, which I hate using that word now, but it trumps the purchase and sell agreement. But it never hurts to explicitly say that in your special steps as well. This term shall, prevail in the event it conflicts with any other term herein. Boom. It covers you. And you're going to look like a rock star with your clients. Approved mortgage lenders. This is a topic Nikisha and I on our last call, we spent about 30 minutes on this. Is Nikisha on this call? All right, so I don't want to, okay. I don't want to overstep what your broker has advised, but you know the loan contingency exhibit, and you know the section where it has approved lenders. I am of the opinion that you should leave that blank.
Yep.
If the agent allows you to. Because if the agent knows contract law, and if they're good, then they're going to request that that section be completed. Does everybody know what section I'm referring to?
Is everybody aware of what Cristyl is referring to? Because this is really important.
And I actually kind of want to read this whole section, because what they've done now is not only, so if let's assume that you left that section blank, there's no approved lender, okay? That means that you can get a loan denial letter from any lender, which is perfect. But now what they've done is you cannot receive a loan denial letter based on certain circumstances. So let's read through those circumstances, because that's important.
And Cristyl, several people have commented they are not aware of what you're referring to.
Ooh, okay, then I need somebody to pull up a loan contingency. Is this section right here, section 2. You see where it has Obsidian Financial Services? If you complete that section, then you can only receive a valid loan denial letter from Obsidian Financial Services. Yep. And let's say Obsidian is not your preferred lender, and let's say they're not really working with you to get you the loan denial letter, then your client is probably going to be out of the earnest money if you can't find another loophole. But if you were to leave that section blank under approved mortgage lenders, then you can get a loan denial letter from any lender. Doesn't matter. Okay, we got a question. Go ahead, Bree.
So I've had an issue where one of my clients' lenders was just kind of dragging their feet, and it was a personal lender that he brought into the deal. And so, of course, my preferred lender was asked to step in, and she graciously accepted. And we literally had about 2 weeks to work with. And so she stepped in to go ahead and get the deal done. Now, if we put someone there, does that also mean that the loan has to close with this lender?
I love that question. No, the buyer has the right to perform up until the day of closing. It doesn't matter if the buyer stumbles upon cash on the ground. And why that's so important is because a lot of sellers, they get antsy, right? And as soon as they see that buyers may not get approved for a loan, they want to terminate so they can put their property back on the market. Mm-hmm. But you can't do that without being in breach. You have to allow the buyer the opportunity to perform up until the day of closing, even after an 8-day unilateral. Now, if you sense that the buyer cannot perform, then you as a seller can request proof that they can still perform, and then they have to provide that proof within a certain time frame. Mm-hmm. And if they don't provide that proof, then you can terminate as a seller without you being in breach. Does that make sense?
Mm-hmm. Yeah.
So this approved lender section, it doesn't mean that you can only close with Obsidian. It just means that you can only get a loan denial letter from Obsidian.
Got you.
So if you are a seller's agent and the buyer's agent leaves that blank, what should you do? Ask them to complete it. Mm-hmm. You as a seller's agent, can you please include the approved mortgage lenders? And the buyer's gonna peep game. The buyer's side is going to peep game, like, oh, she knows or he knows contract law. I see you. I tried to be slick and I see that you caught me on it. So I see you. Let me go ahead and complete it. Mm-hmm. That's what that means. But if you're a buyer's agent, try to be slick. Leave it blank and just see if the other agent notices. Okay.
Would you recommend that we leave it blank or that we put NA?
I would just leave it blank.
Leave it blank.
Yeah.
Okay.
Because you don't want to draw attention to it.
Right.
Because then if I were an agent and I saw an NA, I'm like, what do you mean NA? What do you mean not applicable? Is this cash? Is this a loan purchase or is this cash?
But then on
I'm
top of
with-
that, you're also still producing a pre-approval. You know, so if you put NA, but then you're producing a pre-approval, that's a red flag.
Yeah. But if your client changes his mind at the 9th hour and he's not able to get the loan and he wants to pay cash anyways, he is well within his right to do that. He just has to perform by closing date. And by perform, I mean purchase the property. All right, so let me share my screen again. All right, y'all, we don't have that much more time. Let me take up like, let me take up just a second more of your time because I can sit here for hours, honestly. All right. Okay, so let's go over the reasons that you cannot receive a loan denial letter. All right, so the contract states that you cannot receive a loan denial letter on the basis of the buyer lacking sufficient funds other than the loan amount from the lender. So let's say your buyer had to come up with $20,000 down payment, and let's say that he thought he was going to get it and he couldn't, and the lender issues a loan denial letter. Well, that's still not sufficient because it can't be on the basis of the buyer lacking personal funds. Another reason that it cannot rest on, buyer not having leased or sold other real property unless such a contingency is expressly provided. I hope that's common sense. So let's say that let's say your client is waiting to sell their property and it's under contract and they're just waiting on the closing to actually occur. And in order for this closing to happen, this closing has to happen in order for your seller to purchase another property. Unfortunately, unless you explicitly say in the special steps, this contract is contingent on the sale of blah, 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 then that can't be a basis for the loan denial letter. But you should have that as a contingency anyways, if you can. This market is not very forgiving, but if you can slip that in there, that's what you want to do. Buyer not providing documentation in a timely manner. So let's say the lender gives you a loan denial letter and cites the reason as, oh, we couldn't confirm the W-2s because we didn't receive them from the buyer. Well, that's not a sufficient loan denial letter, according to this term. So your buyer has to actually do everything that they can on their behalf. And they just went on to say this includes loan documentation, the infestation reports, structural letters, septic tank certification, etc. Buyer making purchases that adversely affect buyer's debt to income ratio. The closing is in and around Christmas time. Your client has 5 kids and he needs to finance the purchase from some Toys R Us. And so because he spent $5,000 at Toys R Us, now he doesn't qualify for the loan. And so your lender sends you a loan denial letter saying this loan is denied because the debt to income ratio and blah, 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 blah. That's not sufficient for a loan denial letter. Your client loses earnest money. The property not appraising for at least the purchase price unless this agreement is subject to an appraisal contingency and an appraisal meeting the requirements of the agreement has been performed. The lender not having completed underwriting the loan request. So what that section E says is that you need to explicitly state if there is an appraisal contingency, because you won't be able to rest on the loan contingency as a reason for the purchase or the market value not being what it should be. Does that make sense?
Mm-hmm. Yep.
So treat them separately. Treat a loan contingency and appraisal contingency separately. So if you think the seller has overpriced the home and that it won't appraise, then you need to have a specific appraisal contingency. You can't rest on the loan contingency and a loan denial letter.
Got it.
I think that is kind of common sense too, but it's good that they explicitly clarify.
Yeah.
What are you about to say?
That I'm sure that there's a lot of mistakes made in regards to that. That's why you're pressing it, you know?
Yeah. I mean, there really is. And I don't even have time to go over the pitfalls. So I'm happy to hop on another call and go over some of the pitfalls. Because the pitfalls, that's kind of fun to talk about, after the fact, but it's kind of fun to talk about. The lender not having completed underwriting the loan request. So if you have a sucky lender and they didn't do their job, it can't rest on the generic, lender not having completed underwriting, basically.
Right.
Like it has to be something other than that. And that's it for the loan contingency. And the last little nugget that they changed was deleting this section under FHA loan contingency, which basically said exhibit controls, the exhibit shall control over conflicting or inconsistent provision. But we know, according to the other term, that, where was it? Section C4I, rules for interpreting this agreement, we know that exhibits control. So they just moved the language from one area to another.
Mm-hmm.
And those are the 2022 GAR contract changes. And I encourage y'all, if you've never read the contract from beginning to end, do it. Because if you want to increase your sales, I am not a sales agent, but I do know that knowledge is power and you have the upper hand if you have the knowledge. Mm-hmm. So read that contract. If you don't understand a term in the contract, I can do one-on-one coffee with counsel sessions. There's nothing more than I would love for an agent to schedule a call with me saying, hey, I don't understand this term. I don't understand this, this, and this. Can we go over it? That would totally make my day. So we're here for y'all. And I thank you guys for having me.
Oh, Cristyl, thank you so much. It has definitely been a pleasure for you to join us today and share some information. And we definitely gonna hold you to coming back and talking about the pitfalls.
Very soon.
Yes.
Please do.
Yes. All right. Does anybody have any questions? Oh, she said great info today. PJ clapped her hands. Taya said that was great. So positive feedback. Thank you guys so much. And Cristyl, we really appreciate you guys. And make sure you follow us. TCRG Closing the Gap. If you have any other questions, come off mute now so you can ask Cristyl before we end this live. Marsha says very informative.
Thank you, Marsha.
Nice. All right, guys. Naisha, take us away, man.
Listen, guys, you heard it from, Cristyl. She says she's going to come back and go through the pitfalls of the contract with us. So, if you thought you learned a lot now, definitely make sure you subscribe and you come back for the pitfalls. This is amazing. It was great for me. I learned a lot. Coach, you learned a lot.
Yeah, man, it was amazing. Absolutely. Brandy said, thank you. Good information. Latoya said, thanks. So it seems like it was helpful for everybody.
Well, we're going to see y'all in 2 weeks. Until then, gang, gang, gang.
Gang, gang, gang. Bye, guys. Thanks.
Bye, guys.
See you in 2 weeks.